Copyright, really? It really isn't that long ago that copyright was a subject that preoccupied only lawyers and academics. Most publishing leaders, let's be honest, liked it that way. If they thought about copyright at all, they recognized its importance, but otherwise really saw it as something very esoteric, something marginal to the real business of managing a publishing house. The copyright highway, to use this analogy, was clear, straightforward, and unimpeded. Those days have passed, and frankly, they're not coming back. The road suddenly seems anything but straight, and appears, in fact, to be full of very dangerous twists and turns. Something that used to be easy to navigate is now very difficult, and indeed dangerous to ignore. So it's legitimate to ask what happened in the interim. Well, what happened, of course, was the global network, the internet. That network has transformed the content industry. It's made all of us content creators, as Rosie from YouTube made clear this morning. And apparently overnight, it's made all of us very interested in how content is used and reused. It's a network based on technology that's all about copying, and a network that, for good or for bad, is governed by the laws of copyright. So suddenly we find ourselves on a road that's very bumpy and sometimes extremely uncomfortable. And we ask ourselves, how can copyright laws that were developed a generation ago hope to govern how content on this relatively new network is used? How far should copyright be modernized, extended, contracted, to reflect the new ways in which text, images, music, etc. are used, reused, blended, repurposed, and mashed? Do copyright laws protect or impede the creative industries such as ours? And do they more widely encourage or constrain economic growth? Politicians are inevitably involved, hence the fog area. Sometimes that's helpful, sometimes it's not. But from my perspective, hardly a month goes by without a government somewhere around the world announcing a review of copyright. And politicians are busy, but judges and lawyers are very busy too. And they're often called on to argue and deliver judgments on issues that older legislation is ill-equipped to manage and decide. As a result, important decisions are being made that affect in very, very fundamental ways how your business runs and how the content that you publish may or may not be used. And I suppose the key message here is if you're not paying attention, you're overlooking decisions that are affecting how content is prepared, distributed, priced, acquired, used, and reused. And I'd ask whether you can afford to do that. So let's take a quick tour around the world of some places where changes to copyright law have been enacted or are under review in ways that could affect your business. I want to start with Canada, where the Copyright Modernization Act was introduced in 2012. If you're familiar with this law, or whatever you think of the law, and whatever Canadian legislators intended to happen or not, one consequence of the Act has been for educators, teachers particularly, to see it as a manifesto for unrestricted copying in the classroom. What's the effect of that been? A massive reduction in the revenues earned by publishers from educational licensing and the decimation of the system of secondary licensing in Canada. A government-sponsored review of copyright in Australia has recommended a range of new copyright exceptions, including what it calls a broad, flexible exception for fair use. Not surprisingly, there are many commentators in Australia who believe that radical changes are coming that will damage the interests of publishers if these recommendations are implemented. We've already seen, and we're about to see more, copyright exceptions introduced into UK law, covering various educational uses, text and data mining, orphan works, and much more. New copyright legislation is imminent in Brazil, and that's rumored to be profoundly hostile to the interests of rights holders, both publishers and authors. Such is the pace of legislative change, it's legitimate to ask if what we're seeing is really copyright reform or the erosion of copyright protection. But some of the most far-reaching changes to copyright are not happening in parliaments and legislatures around the world, but they're happening in courtrooms, where judges are hearing cases that test to breaking point the legislation already on the statute books. Some of it, as in America, where I'm based, passed more than 40 years ago. Going to trial can be a lot like going into an unfamiliar tunnel. You really can't be sure what's coming on the other side. Now, for those of us who have the interests of rights holders, authors and publishers particularly, at heart, there have been some very high-profile accidents in the courtrooms of late. Judge Denny Chin, for those of you who've been following the Google book settlement, recently announced in the federal court in the Southern District of New York that Google's digitization of 17 million books without ever asking permission from a single author or indeed from a publisher was, quote, fair use. Whatever you think about that, whether you think that was the right decision or the wrong decision, that has a profound impact on publishers and authors. In the Supreme Court in the United States, there was recently a decision in the case of John Wiley & Sons versus Kirtsang. If you're not familiar with this case, Mr. Kirtsang was a young, entrepreneurial-minded gentleman living in the United States who discovered that it's much cheaper to buy John Wiley textbooks in Thailand than it is to buy them in the United States. So he got his friends and families to buy large numbers of copies of Wiley textbooks in Thailand and re-imported them into the United States, where he sold them at a significant profit. The Supreme Court of the United States decided that that was legitimate and was a legitimate extension of the first sale doctrine. Now, whether you admire Mr. Kirtsang as an entrepreneur or whether you admire John Wiley's efforts to protect their legitimate interests in this case, it doesn't matter what side of the argument you come down on. Here is a case where the Supreme Court of the United States of America made a decision which has profound and far-reaching effects, not just on the business of John Wiley & Sons, but every publisher around the world. Now, while it may be easy to get despondent about rulings such as the ones I've described, sometimes the appeal courts come to the rescue of publishers and authors. We're hoping, certainly I'm hoping, that the appeal court will come to the rescue of rights holders such as Oxford University Press, Cambridge University Press, and Sage in the litigation they're taking against Georgia State University in the United States for the use of their copyrighted content in e-reserve systems. And there are others that I could point to. Other high-profile cases are still working their way through the court systems, and we're going to have to be very patient while we wait for decisions that might take several years to emerge and be confirmed. One is Oxford University Press, Cambridge University Press, and Informer's litigation against Delhi University in India, where there has been wholesale copying, I would say illegal copying, of those plaintiffs' works for inclusion in course packs in Delhi University. But again, litigation of this kind takes a very long time to work its way through the courts. And it's creating a significant period of uncertainty for those involved in academic publishing in those countries. Now, a licensing system that's fair, effective, easy to understand, and easy to access is the way forward, and will be the most important part of the copyright landscape in the future. Legislation, judicial rulings, and enforcement actions, they all play a vital part, of course, but we mustn't forget that users will respect your content and conform to the terms and conditions you set for its use and reuse if together we put in place a licensing regime that is firstly visible at the point when content is accessed, secondly that is transparent and easy to use, and thirdly that balances the interests not just of content users but of rights holders as well. In conclusion, let me say, even in this complex environment in which content is shared frequently and rapidly, with these fundamental rules of the road in place, we can ensure that the desired ends of both content users and rights holders are met. Thank you very much for your time.